SJC-12722, Maura Healy v. Timothy J. Cruz and others.
Give me 1 second.
That's okay, Mr. Connolly.
Good morning.
Good morning.
I'm Thomas R. Kiley. I appear today as a Special Assistant Attorney General. I'm specially appointed because the lawsuit that underlies the dispute that you're about to hear is really an attempt on the part of the district attorneys and the Attorney General, all of whom are criminal justice agencies, to get a resolution of the way the Corey Act and the Public Records Act interact. And I come at the question from a different perspective than you heard from the Solicitor General and Mr. Albano, both of whom have lots of experience with respect to the public records law in particular. I heard the court talking about end arounds, an end around the Corey system. The defense to an end around is not to over pursue. Defensive ends know that. Old high school jocks know that. It is the case. I come at this from the perspective that when you start the inquiry by starting the focus on the public record law itself, that's a faulty premise. There is a difference between a record, which has a statutory definition. In Chapter 66, that definition is in Section 3. And an information system, a database, as Mr. Albano referred to it in the last argument. We have a statute, a specific statute, Corey, the Criminal Information Act, Chapter 6, that deals with information systems. And information systems where there is an aggregation, where the scope of the material is of huge dimension. Databases are subject to manipulation. They're subject to all kinds of abuses. And what we had in 2010 is a considered judgment by the legislature dealing with how it is that access to this specific species of information, criminal justice information, was to be distributed to the public. The court undertook its own analysis of the policy issues in coming up with its own rules. It's not a new problem on the horizon. Starting in 2003, 2004, there was a lot of national attention paid to this particular phenomenon. The National Conference considered it. It's been considered and hotly debated for a period of time.
Well, what was reconciled in 2010, excuse me?
2010 is the amendment of Chapter 6. It's the Corey reformers, Justice Swank, as I would refer to it. So 2010, the decision, the policy judgment made by the legislature and the governor with respect to how it is that access is going to be given to information systems and all of that stuff that's on the information systems, that's when the judgment was made. And it was modified in 2016 and in 2018.
So it's reconciling what, is I suppose my question. What is it reconciling? You said it was reconciling. Is it reconciling
The various
Corey with the
what
Public Records Act? Is it
what I was referring to, Justice Swank, elliptically, is the controversy that existed as to how to reconcile or how to deal with these huge amalgamations of information that might come about through the access to information systems. And I want to point out, because the court appeared particularly interested in the last argument, with respect to the public access, the interest that one might have in the police officers or the public officials who might be seeking access, the Globe and others might be seeking information, access to information about them. That statute, Chapter 6, Section 172A6, specifically allows members of the public access. They may petition the Commissioner of DCJIS for public access upon a showing of public interest. And the DCJIS regs 803 CMR 8.03 also permit access to what otherwise would be criminal information or offender record information for research projects upon showing of a valid public purpose.
I guess I have a really simple question. I'm not saying the answer is simple, but the question's simple. Isn't everything in the DA database also in the clerk's file?
No, no, but everything that is in the clerk's file that might work its way into the database would be accessible through the portal that is provided, and it is specified in the statute and made accessible to the public. When I talk about a definitional problem, I think when you compare the definition of record, the definition of public record in Chapter 4, Section 11, Clause 26, and the definition of criminal offender record information, there are differences in those definitions, in all of them. The definition of a record at the time relevant in all of these cases in Chapter 66, Section 3, did not include things that were done electronically. Electronic was added in 2016. Records that were kept electronically were added to the record statute by Chapter 2000 and by the statute in 2016 that took effect in January of 2017. When we are talking about the specific provisions of the criminal justice information system, it does apply to materials in any communicable form. Communicable was the word, I think that the state solicitor referred to in any form. It's any communicable form, and that's in the Corey statute in Chapter 6. That is not the definition that exists with respect to public records, and that's not the definition until 2017 for records generally.
Now, the 22 categories, case ID number, is that an internal DA number, or is that the docket number?
Not specified, Your Honor, but if I can deal with the request that's before you, because I think that's where you're taking me.
Right.
So the request, as is laid out in the oppositions by the various district attorneys' offices, morphed over the course of time. The first paragraph asks for all data in all fields within their computer system. It addresses very directly criminal justice information systems. The paragraph which follows says in Mr. Wallach's letters to each of the district attorneys, I am willing to narrow my request to, and there are then these 23 categories.
23 or 22, I thought.
22, yeah. I'm sorry. I can remember plays. I can't necessarily remember the numbers. The judge in this case presumed as Justice Lowy's question does, that all of the material that is in those 22 categories is available through the court records maintained chronologically, or it's available through, I think it's called the Office of Commissioner of Probation carry report. There is a printout of sorts that is in existence on the website daily of materials that are handled in the court. Much information is in that.
Okay, I guess
first two or three
what
categories-
I'm trying to get at, to get to the heart of it, is the AG, I guess, in an earlier hearing, agreed that you could identify individuals, but my understanding is it's only from the docket number, which you could then check against against our public portal. But I'm trying to figure out where the docket number is sought here. Is it?
What I would say to you is that there was an agreement on the part of the Commonwealth in this case by the Attorney General's office that that one could utilize the information, and Judge Conley referred to it as an end around, as a matter of fact. Simply, you could connect and identify an individual with a few simple expedient steps.
Okay, I'm trying to
It
trying to look more
included-
carefully at that. As best I can tell, all the other information, which doesn't identify name, are all internal to the DA's offices. The defendant ID number, I assume, is known only within the DA's office. I'm trying to figure out how that could be accomplished, and then would be asking the question of you and of the AG is, what if we simply said you get 21, but you don't get 22? If the 22nd one is the one that would enable you to identify that individual and do the end run that we are concerned about.
So I'm going to answer it in two parts, and you're going to take me to the second argument I would be making, that there would be a requirement that I'm creating a new record, and it was an issue that was advanced by the district attorneys in their oppositions to the materials. It is their position that the Supervisor of Public Records manual said that there was no requirement to create a new record, and that it was based upon an opinion by a very august Attorney General from 1970s. I'm going to then respond to the first part of the question, and that is that the request that was before the Supervisor of Public Records that the Attorney General sought to enforce was based upon presumptions about what could be there, nothing in the agreed statement of facts. This case went on an agreed statement of facts, and the judge, as any Superior Court judge I submit would have, using the paradigm that I suggest is the false paradigm, simply looking to start with the public record law and the Middle District case from 2003 would have reached and found it controlling, and would have also found, as I think Mr. Albano said, that Reinstein, or it might have been Mr. Witt, might have mentioned that Reinstein talked about the insertion of segregable portions in the public record law.
So here's the issue. I don't understand, and I think the chief might be getting to this issue as well with the last question. When Judge Conley talks about you could theoretically puzzle together who the individual is from this data, how big a deal is it? How hard is it to puzzle it together?
Easy. But what I would also say is, from the district attorney's perspective, from the administrator of the database, persons within those offices, they would have to write a script and query the system. So you have a database, there are programs. The district attorneys would have to write something called a script. They would have to, in order to exclude, they would have to then query the system. And when you look at the record in this case, what you're going to see is that there were orders to query the system, and the district attorneys universally expressed concerns about the burden that that would create on them and argued that there was no need to create. But, I'm sorry, Justice Gaziano.
My assumption was that the docket numbers are in the Damien database, because it would make no sense otherwise. A DA's database would be worthless unless they knew the court docket, and maybe it's a false assumption. And then once you get the docket number, that's the key to the castle that allows the end run, correct?
It is certainly a key, yes. I think that it is common knowledge that the Damien system is simply it's a system that's administered through the DA's association, that there is a maintenance provider, that every DA's office uses it differently.
But that'll be in the record anyway.
It's in the record, and what is in the record is that there is nothing in the record, the agreed facts, that supports the notion that there is anything here, that everything here is simply in the court records. But I want to make one really, I see my time
But
is up
it
too.
also includes the DA's disposition, recommendations and the like,
Yeah.
which certainly wouldn't be in the court record.
There's plenty of material in the Damien systems that are used in the various offices that is requested by this, give me all of the information in your systems, not limited to Damien, by the way. You got Cognos, you got another system, that's requested too. But there's nothing in the record that would support it. What I also want to point out with respect to Corey reform is a fundamental goal, as the state solicitor suggested, was to steer the requesters to that reliable database. And to the extent that Mr. Wallach is creating a database drawn from all of the DA's offices with all of the fields, with no time restrictions. It's everything that you have. You have created a huge end run around Corey and the Corey reform. Trying to get in this electronic age, as in the public record, the case involving the DPH, where there was a remand, this aggregated information is different in kind. It needs to be analyzed as different in kind than the request for Tom Kiley's arrest report.
Can I just ask a question about the amicus from CPCS? I don't know if you saw it, but they made the point that without that type of information, it would be difficult to gather the data necessary for the data that we said a defendant would need to show under Laura, that there was some discriminatory practices. So I didn't know if you had any response to that.
I think that information is available through the CJS system upon a proper request. I think that you could go to DCJIS under the provisions that I cited and tell them that there's a public interest in that information and get access to that information from the reliable system that exists.
So this isn't a Corey issue then?
Well, that is within, Corey is within the CJS statute. So it's all within chapter, all of the coverage is within chapter 6.
And just to be clear, other DA's offices have turned this information in?
Yeah. And Judge Conley noted this, and it goes a little bit to your question about whether you're going to be telling people they've violated the law. Again, I think the statute contains provisions that protect the good faith production. There was a request, or a series of requests, the record shows, starting in 2014. They went to all the DAs. They went to CJS, they went to the Attorney General, they went everywhere. Initially, and this again will be in the record, all of the district attorneys except one objected to the production. In August of 2015, I believe, I might have my year wrong, there was an order from the supervisor of records that went to 10 of the district attorney's offices. Another order on December 31st of that year that went to 10 of the district attorneys, 7 of whom had been resisting on this Corey basis, among other things. And then when the matter was referred to the Attorney General, again in the record, there were 3 district attorneys, the 3 who are the defendants today, who had still not produced. And again, each of them has very strong views about the protection that Corey provides, and each of them joins with the Attorney General in asking the court to try and come up with a reconciliation of the 2 statutes. And I submit that in terms of dealing with information systems, the specific later enacted statute dealing with access to information systems is the one that should control.
Following up on Justice Budd's question, does the CJS have information with regard to race and/or ethnicity?
I can't answer for certain. I believe so. I believe it's available.
I will ask for a 16L letter to advise us as to whether this option is indeed available to evaluate
I'll be happy to.
the risk of racial disparity, because I'm skeptical that it would contain race and ethnicity, because I don't think our court records maintain it on that.
If the court records don't show it,
Our probation records
Don't
do,
know
but
where
not
they
our
would
court
get it.
records. Right, so that's why, so it may be that this is the only place where that information is available. Let me also follow up on a question Justice Gaziano added. So I guess the question is, what if we took away the key to the castle, but said you get everything else?
as a matter of public record, I think it would be wrong. I'm not,
Wrong.
never
I
refused to have
the
a
key-
loaf.
The key to the castle, meaning that you'd provide information which would not permit you to do the end run around Corey because you would not be able to identify through a docket number the individual whose information is being furnished.
May I suggest an altered phrasing that may do the same thing? Were you to say that a public record remains a public record when it goes into the hands of another public official, as was the holding in the Middle District case in 2003, and if indeed the district attorney gets that same document would be a public record because of the way the statute and the public record statute and 6172M that was talked about before and wasn't changed in Corey reform interact. If a district attorney gets and has that thing that comes from the court, it's a public record, if you were to say so, and it should be made available. To the extent they don't get that record, I think it's a different story, because the way 172M works, the provisions of Section 3 subsection 3 and M deal with published reports, and when the CJS system publishes a court record report to the district attorneys, that's a public record, and it remains so. What they have in their database is not. That's how I would answer, Your Honor. So if I'm not asking you to overrule the 2003 case. I think that you've can harmonize it as easily as you can harmonize the statutes.
Okay, thank you. Ms. Benedon.
Good morning, Your Honors. May it please the Court, Assistant Attorney General Carrie Benedon on behalf of Attorney General Maura Healey. Your Honors, the Attorney General brought this action in Superior Court pursuant to the enforcement provisions of the Public Records Law because this Court's 2003 decision in the Middle District case mandated that the records at issue here be disclosed. Despite other changes to the applicable laws, including 2010 Corey reform and 2018 criminal justice reform, the relevant provisions of the Public Records Law and the Corey Law have not changed. In support of the Attorney General's argument today, I'd like to make 3 points. First, under the Public Records Law, records are presumed to be public unless an exemption applies. The only exemption that has been claimed in this case and argued below is Exemption A, that is that the Corey Law acts to exempt the records from disclosure. Second, the Corey Law itself, at Chapter 6, Section 172M, specifically provides that the type of information, the type of records requested here shall be public records. And third, the policy considerations behind the Corey Law, including the 2010 Corey reform as discussed by this court in the Pond case, can be reconciled with disclosure of the public records. As this court knows, the Public Records Law is the critical tool that provides the public with broad access to government records. As recently as September, this court acknowledged in particular with regard to records of the judiciary, the unique interests of the public in ensuring that justice is being carried out in a fair and an efficient manner. There are strong policy considerations that favor openness and transparency, not the least of which are those that CPCS raised in its amicus brief.
Can you help me? Is the AG's position in this case consistent with the AG's position in the last case?
Yes, it is, Your Honor, because the records that are requested are different here. There, I believe, is no question that the records here, at least all but 3 of the 22 categories of records requested, could fall within the Corey Law and specifically the exemption in Section 172M that states that these shall be public records. And with regard to the other 3 categories, as the Superior Court found, there was not a sufficient showing made under the Public Records Law to withhold those records.
And what are those 3 categories?
The 3 categories of information that may not be in court records are the DA's own defendant ID number, case ID number, and the sentence or disposition recommended by the prosecuting attorney. But they have not developed those arguments, certainly in the brief to this court, and again, the Superior Court found that they, as the party carrying the burden of demonstrating the applicability of an exemption, had failed to make that showing. But the remaining categories of information, there has been no dispute, are the types of categories or the specific information that is maintained in the court records that would be available from the court's office. And that is why this court found in 2003 in the Middle District case that the types of information requested here must be disclosed. In its 2003 decision in the Middle District case, this court started by saying that if an item sought is a court record that could be obtained from the clerk's office, then it's a public record and may also be obtained from any other agency.
But the problem you've got with this argument is that the court system itself considered what to do with regard to the disclosure of court records and was concerned about the end run of Corey and therefore limited the public portal to not permit individualized requests that would allow somebody to essentially pull together a criminal history that would not be available under Corey. So how does your argument fit with what the court itself did with regard to its own records?
So the court did make that change through its adoption of its own rules. The legislature, however, notably, despite making 2 very significant and robust rounds of amendments to the Corey Law, made no such changes to the language in Section 172M, despite clearly having the opportunity to do so, and despite recognizing that this court issued a decision in 2003 that interpreted the language in 172M and found that information, not even necessarily literal copies of records, but or the same information that is contained in a court record shall be disclosed, is not a public record.
Well,
and so the legislature has addressed that issue, or can be presumed to have considered that issue, and made no changes, therefore implicitly recognizing that the balance of interests that was established in the Corey law pre-2003 and remains today is the legislature's intent with regard to access to those types of records.
Let me, I guess, ask you, is it your view that race and ethnicity is contained within court records?
I am not aware with the race and ethnicity. There has never been an assertion here that the race and ethnicity is not contained in court records.
Nice for us to know in response to Justice Budd's question and my own whether or not it indeed is within the realm of decisus. So whatever, I'll invite each of you on the 16L letter to inform us whether or not decisus and Corey include any information with regard to race and ethnicity. I'm skeptical it does, but you'll tell me. But going back to the end run, so you're saying even if it is an end run, Corey requires it?
I submit that it's not an end run. It is literally what Corey requires, and so
But let's examine the end run. You apparently conceded that you could take this database and then use it to generate a criminal history. How would you do that? Or how would one do that?
Well, to clarify a question that was asked earlier, the docket number is one of the categories of information that was requested and that is maintained in the DA's database.
What's it called here? Because I don't see anything of the 22. I don't see anything that says docket number. Is it?
Yes,
just
it's
case ID?
in the record on page 20. The request specifically included a request for docket number. And then subsequently, page 26 through 40 are different iterations of the request because the requests were revised after responses from the custodians, and the docket number remained a part of the request.
Okay, so if you have the docket number, you could then go to the court case and you could say docket number means it's a case against John Smith, and then you would then have the ID number, and then you could use that and use the ID number to identify all the cases in that DA's offices which concern John Smith.
Our office has recognized, including in argument to the Superior Court below, that with the information gleaned from the DA's records, an enterprising individual or reporter or company could take the information and go one by one through the court records, either in the clerk's office or using online access, depending on the court that the record arises from, and line up the information using the docket number.
What do we do with the Corey? Corey says that it doesn't just protect people who are identified. It protects individuals who are identifiable. So what do we do with that?
There has been no evidence or information included in the record in this case indicating how easy it would be to do that, whether it is feasible to do that. It's also not clear that even without the docket number that couldn't be done. It is possible that the docket number, it's been referred to as the keys to the castle, that might make it easier. But there has never been an argument or information presented in the record that we have before us indicating that would be an easy task to do, or that the technology exists to do that, short of having to go through one by one, which again could be done. If an individual went to the clerk's office and sat at the computer terminals, they could obtain all of this information one by one, going through each court record, and could take that information and compile it in the same way.
Well,
and so,
actually, you couldn't. You'd have to go to 99 courthouses.
that's correct. That's correct.
So, but with this system, you could go to one courthouse. If you say you were in Plymouth, you could go to Brockton, identify the docket number, and then you could go to this information and say, okay, well, I know that the docket number means it's Jose Ramirez, and Jose Ramirez, I now have the defendant ID number, which is what the DA uses to identify Jose Ramirez, and then I could use that to identify all the cases in Plymouth County that the DA's office has, which concern Jose Ramirez.
Your Honors, this possibility.
Much easier than going to 99 courthouses.
This possibility existed in 2003 as well, when this court issued its decision in the Middle District case. And again, the language in that case, although the requests at issue there were narrower, they sought records related to a particular type of offense involving public corruption, the language in that case is quite broad and does not, and this possibility existed at that time, and the language didn't in any way limit the holding as applying to cases where an individual couldn't be lined up with other records gleaned from other courthouses or matched up with other records that might exist within the database. Docket numbers were specifically one of the pieces of information that were requested in the request that led to the 2003 decision.
So let me ask you the question that I asked of Mr. Kiley. What if we say you get this information, but you don't get the key to the castle, you don't get the docket number?
Our position is that this information is all subject to disclosure under the Public Records Law, and so if this court ruled that that piece of information is not, then it's not clear from the record whether the remaining 18 or 19 categories of information would still enable a requester to reach the same result, to essentially reverse engineer the information. That issue has not been raised, the argument has not been made here. Instead, what we have is again, going back to the Corey law and focusing on information that is in the court records. I believe that based on this court's 2003 ruling, and even setting aside that ruling, looking at the language of the statute itself, it is clear that information that is in the court records shall be subject to disclosure. And so there's no question that the docket number is information that is in the court records and would be subject to disclosure. There would not seem to be a basis for treating that piece of information differently than all of the other information that is maintained in the same court records and is subject to the same provision, Section 172M of the Corey law, stating that all of that information is public and shall be disclosed.
So now you have another situation in terms of the end run, not only with regard to Corey, but the end run with regard to the court rules. And I know the court's not within the public records law, but you could not do a request by name and say, give me all the docket numbers that relate to John Smith. But you're saying you could do the same thing to the DA's offices.
Well, that request would have to be done through the individual courts. If somebody went to the 99 courts that have been mentioned, then that information could be obtained from court records. And again, some courts' records are now available online, and so an individual could search that information online, even in accordance with the court rules as they currently exist. And my understanding is that additional courts' information will be coming online in the near future. And so it is, and again, this information is not developed in the record, but it is not so clear based on the information that is available through the courthouses how much more burdensome it would be to get this information directly from the courts rather than from the DA's office's database.
It's hard to figure out whether it's easier to go to 99 courthouses than just to write 9 letters to DAs
Much of the information is available online already and can be searched through the public portal. In particular, criminal cases from the superior courts, there is currently greater online access through the public portal, which would not require going to a courthouse, and records that can be searched by name. Again, you would have to individually select the court that the case arose out of, but then the information could be searched by name, and my understanding is that that access will be expanding to include additional courts and that public search function over the internet. Turning to the policy considerations in this case, when considering the policy behind the Corey law, it is important, as I mentioned earlier in my argument, to not forget the policy considerations, the significant policy considerations that underlie the public records law in the first place. In this court's recent decision in the show cause hearings case, the court did state that we've long recognized that public access to court records promotes transparency, accountability, and public confidence in our judiciary. That's a significant interest. We do recognize that that case ultimately reached a different outcome, but it turned on a recognition that the records at issue in that case were fundamentally different because of the timing and the stage of the proceedings. The purpose of the Corey Law is to prevent a person or an employee from being able to easily enter a name into a government database and then output their entire criminal history. But that doesn't mean that the information is not already public, as we've discussed here, and the legislature has struck that balance, has kept that balance in place, and this court should adhere to its 2003 ruling, which recognized the legislature's recognition of that balance, and find that the records here should be subject to disclosure under the Public Records Law in accordance with the Corey Law.
Okay.
Thank you.
Thank you. And we'll take our morning break.